Yes, sir.
Would you please raise your right hand? You solemnly swear that in this proceeding, the information and responses you submit will be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you. You may put your hand down. Mr. Carney, before we proceed, there are several things that I need to discuss with you. It will be on the record. Ms. Kayleen Rivera is a certified court reporter. She's making an official record of this proceeding. The matters that I'll discuss with you right now orally will be recorded, and then we will probably repeat this 2 to 3 times in writing. First thing is your constitutional rights and protections. Number one, you have a right to remain silent. That means you do not have to make any kind of statement. You don't have to answer questions. You don't have to submit paperwork with your signature, especially papers that in which you confess or admit to wrongdoing. That is the right to remain silent. Do you understand that you have that right?
Yes, sir.
You have the right to a jury trial. That means that you and your attorney and the state's attorneys, the prosecutors, would select 6 people from what's called a jury pool or jury panel, randomly selected, and then you and your attorney and the state would select from that panel 6 people who would hear the evidence, see the evidence, and the testimony given. Whatever materials would be evidence would be also considered. They would then decide whether you're guilty or not guilty if you went with a jury trial. You understand you have that right?
Yes, sir.
You have the right that is called the right to confront witnesses. Sometimes it's basically called the right to face your accusers. You and your attorney and the state can cross-examine, question, or challenge any witness who would testify in your trial. You understand you have that right?
Yes, sir.
There's also a right called the right to appeal. Generally speaking, that right means that you yourself or your attorney by himself or the two of you together could demand that a higher court review the official record, the evidence, the testimony, everything that's relevant in this case. You'd have to follow the rules on the paperwork and on the time limits. That's called the right to appeal. You understand you have that right?
Yes, sir.
And finally, you and the state individually, each side on their own, have the right to demand that this matter, this hearing, this proceeding be held in the open public courtroom. Because of the COVID pandemic, we've not been doing that. And what we're doing is what's called video conference. This is being streamed on YouTube so the public can see it, hear it, see you, all of us. That right is one you have and the right has separately. Do you understand you have the right to demand an open public courtroom hearing?
Yes, sir.
All right, now I'm going to show you the paperwork in this case. The papers will, just with one exception, the papers will start with some identifying information. Almost all of them will have what you see on the screen right now. At the top, the case number, which is 652444. That is your case number on the charges. It's the state of Texas versus Gabriel Kendall. Pardon me, I have that wrong. It's the state of Texas versus Taylor Franklin Carney. In the County Court of Law number 5, Bexar County, Texas. That will be repeated on almost every one of the documents. It is basic identifying information. Below that then will be the title of the particular document. This particular document is called State's Consent to the Video Conference. I said a while ago that both of you have the right to demand an open public courtroom proceeding. With this, the signing of this document, Ms. Caitlin C. Morgan has, on behalf of the state, on behalf of the district attorney's office, agreed to the video conference of this proceeding. Did you review this document?
Yes.
The next document is titled Discovery Acknowledgement. Again, at the top, it has the identifying information.
That's a judge.
The title of this particular document, by the way, all the titles will be in all capitals, bold print. This particular document talks about a law, and you don't have to, you'll see the first line there. It's Article 39.14 Code of Criminal Procedure. You don't need particularly know that, but what you need to know is that this is a law that requires in any criminal proceeding that the state shares with you, acknowledges, and makes available to you all the evidence, documents, receipts, books, videos, whatever is involved. They have to do that. Now, if you'll notice, this document is signed by your lawyer and the state's attorney. They are saying to the world in this official document, that law that we were just talking about, that law has been obeyed. Did you see and understand that document?
Yes.
The next document is yours. This is the one where you agreed to the video conference. Did you review this and sign it?
Yes, sir.
All right. Now, the next document is called, what's that square in the middle there? This document is called Defendants Waiver of Constitutional Rights and Court's Admonitions. I've never liked the way that reads. However, that document, after the identifying information, it is an important document in that there has 3 sentences that are separated. Starts up at the top. The second sentence, can you read that?
I understand that in this case, I am charged with the following offenses: DWI with a BAC of 0.15 or higher.
All right. That means it's basically called extreme intoxication. But what does the next sentence say?
In this case, I hereby enter a plea of nolo contendere to the following allegations: DWI.
Okay, it's just DWI. Now, what that tells me as a judge, and obviously that's been an agreement that your attorney has gotten for you, you're no longer charged with, you will no longer be charged with DWI extreme intoxication. The state's gonna drop that for you. Now, the rest of this document is divided into 15 numbered parts, substantially. So the very first one, number 1, it talks about DWI first. And this is the range of punishment. Number 1 is range of punishment. There's a vertical stack of little boxes, and next to each one is a particular punishment, either the level of punishment or for a particular allegation or crime. The very first box is check marked. What does that say?
DWI first, $0 to $2,000 fine, and 72 hours to 180 days in jail. Okay,
so it is obvious that you read and understand what you're reading. Is that correct?
Yes, sir.
Mr. Slimane, did you, as his attorney and as an officer of this court, did you review this document carefully with your client?
We discussed its contents, yes, Your Honor.
And are you satisfied that he understands the contents of this document?
I'm satisfied, Your Honor.
All right. Mr. Carney.
Yes, sir.
A couple of things of importance. One is, where were you born?
New Braunfels, Texas.
Okay. Some people might question it, but that is the part of the United States of America, isn't it? That makes you a citizen.
Oh,
And that is so noted in the papers of this case. One of the things that I need to be sure you are aware of is that the deal that you and your attorney have made, the agreement, as the judge, I am required to say yes or no. I can approve it, which is normally what I do, or I can say, nope, I don't accept this. In addition, we've gone over, in fact, you read the punishment that's available for DWI first. I can give you any punishment in that range of punishment, even if it's heavier than what you agreed to. However, if I reject your deal, say, no, I'm not accepting this, or number two, if I say, I'm giving you a punishment that's greater than what you agreed to, then in that case, the law would allow you to start all over again, and nothing that you've said or signed up till now would be used against you. Is that clear?
yes, sir.
All right. Do you have any questions about this document?
No, I do not.
And you did sign it?
Yes, sir.
Okay. Then we're going to proceed to the next document.
It's not me, Judge, it's Caitlin.
Oh, okay. At this point, what we have is my certification to you. As a judge, I am certifying to you. There's again a vertical stack of boxes, and each one of them says something different about a right of appeal. The fifth one from the top will be marked. And that is the one where I hereby certify to you that this is a plea bargain case. It's a deal, and you will not have any right of appeal. Did you review this document with your attorney, and did you understand it?
Yes, sir.
All right. So I will be signing that and approving it in the record. It's for deferred. All right. What you're seeing now with, again, the identifying information, this document is titled Application for Deferred Adjudication. There's several things about this that I need to make sure you're aware of. First of all, this is a form of community supervision. Generally speaking, it's called probation, but this is a particularly good, beneficial deal that your attorney has made for you. This one says essentially that even though you're pleading nolo contendere, which this court takes as a guilty plea, and a nolo contendere is sufficient for me to convict you, this court will not find you guilty and will not convict you at this time. That's why it's called deferred, or might call it postponed. If you live up to 100%, and listen carefully, if you live up to 100% of the conditions of supervision, then the case will be dismissed and you are not convicted. There will not be, in Texas, under Texas law, there will not be a conviction. If you mess up and you either fail or refuse to live up to the conditions of supervision, then the state will ask me to give you official notice, bring you in for a hearing. And I may at that point, first of all, enter a final conviction. And then you'd be looking at 100% of the punishment range: fine, $0 to $2,000, jail, minimum 72 days to 180 days. Now, just to be super clear, the conditions of supervision are going to be read to you. You're going to sign them, and you will have a copy in your hands. Is that understood?
Yes, sir.
Do you have any question about deferred adjudication?
No, sir.
Do you understand what you signed and said to me when you signed that application?
Yes, sir.
Very good. All right. Now what you're being shown is the one document that doesn't have identifying information at the top. And that's kind of understandable because this whole thing is identification of you. Name, address, phone number, the whole routine. Where are you working?
It's called Off the Grid 4x4s, off-road shop.
What do you do there?
I'm the manager and the lead installer.
And what do you earn?
25 hourly, 50 hours a week.
And do you work just 40 hours, or do you work overtime?
Right now it's just Monday through Friday, so it's anywhere from 40, maybe a little bit over 40.
All right. So you're looking at essentially $1,000 a week.
Yes, sir.
Okay. Now, you are married, and you have 3 dependent children under 18?
Yes.
All right. And did you serve in the military?
No, sir.
Okay. And you have a maroon Chevy. I'm sorry, I'm having trouble seeing it. My eyes are not good.
Silverado.
Silverado. What year?
2003.
All right. Okay. And all of that information is true and correct. Is that true?
Yes, sir.
Now you're going to be shown what's called a plea agreement. That is essentially the deal, what has been agreed to. The first 2 boxes that you see there will be marked. The first one talks about your constitutional right and protection, particularly the right to remain silent. Then the second box identifies you as a U.S. citizen. Next to that is a section with 5 vertical boxes. Each one talks about, again, your rights and protections, your constitutional rights. Did you and Mr. Slimane review this section and mark the boxes?
Yes, sir.
All right. The next section talks about DWI. The state is making a motion officially. What is that, Ms. Morgan?
Yes, Your Honor, the state moves to waive and abandon the extreme intoxication enhancement and proceed on a DWI unenhanced.
Very good. Defense, any objection?
No objections, Your Honor.
There being no objection, the court grants that motion. Now, what that means, Mr. Carney, is officially and on the record, you're no longer charged with DWI extreme intoxication. You're now charged, and the official papers will show DWI first. The more maybe technical and proper way says DWI misdemeanor B. Now, to the charge of DWI first, also known as DWI misdemeanor B, how do you plead, sir?
Your Honor, this is Nathan Slimane. I see the paper is marked not guilty, but in discussion with Mr. Carney, the plea that I understood he intended to enter is no contest, nolo contendere, as indicated on the earlier document.
Okay, Mr. Carney.
Yes, sir.
I will have that changed to show that you are pleading what officially, sir?
Nolo contendere.
Okay, that will be reflected in the papers. Now, I find that there's sufficient evidence to find you guilty, but I do not find you guilty. I am granting you deferred adjudication of 1 year. You are fined, what does it say?
400, probated 400. 400.
But what is the original?
400.
Okay. I will tell you right now, there's going to be a little bit of a problem because this thing says you're fined $400 and there's some that's being probated. Because I'm not at my own computer, I'm having trouble reading it. But I will tell you this.
Can I ask Ms. Morgan to enlarge it?
I will not agree with the $400 fine, nor will I agree with any of it being probated. I will tell you, thank you.
Ms. Morgan.
Is it Morgan that's doing it?
Yes.
Ms. Morgan, thank you. I am going to fine you $750. And none of that will be probated. You are quite fortunate that your attorney got this matter reduced. You are fortunate in that you have a good job. Does your wife work outside the home?
She works late nights delivering pieces.
All right, so she makes a little bit of money too, is that correct?
Yeah, just a little bit.
Okay. Now, you will perform 48 hours of community service restitution. Now, let me explain one thing. Because I have fined you $750 and I'm not probating any of it, that is an increase of the punishment. And as I said earlier, if I give you a fine or punish you heavier than what you agreed to, you have the right to say, no, I don't agree. Let's start all over again. So keep that option in your mind at this point. Perhaps you and Mr. Slimane might want to be conferring further, or you may be ready to say, okay, I'll accept that deal. It's up to you. But anyway, at this
Your
point,
Honor.
I'm not asking you to decide. Yes.
If I may, the reason the state had probated the fine was given that he does have 3 younger children. I believe the oldest child he has is 7 years old. And I know that that is an expense in and of itself.
Yes, Your Honor, and this is Nathan Slimane. Just to add on that, the ignition interlock that he's going to have, that costs money. The DWI education class and other requirements cost money. Supervisory fees cost money. His vehicle is almost 20 years old. I don't know that we're necessarily getting a full picture of his financial situation just by virtue of the fact that, you know, he is fortunate enough, and I agree that he is fortunate enough to have a job that keeps him busy during the day. We want him to comfortably be able to afford and satisfy his requirements to the court that he's agreeing to, these additional financial obligations, without any risk that there's going to have to be any hardship felt by any of the children going forward. So respectfully, in
what was
concert
the
with
reference? I'm sorry, Nathan, what is the reference to the 7-year-old? What's going on?
his oldest child is 7. He has 3 children, ages 2, 3, and 7.
Right. But there's no special needs or anything on the 7-year-old?
Not that I'm aware of, Judge, but I would have to, Mr. Carney would have to speak to that.
I'm just making sure that we don't have a disabled child or a child with special needs and expenses. The 7-year-old is a normal, healthy child. Thank God. I hope he is.
Yes.
Okay. All right. I've heard what's been said. Now, in addition to what I have announced at this point, as part of the agreement, you have agreed that you will participate in, enroll in, and complete the DWI education program, a TAP evaluation and the recommendations. You will have 6 months of ignition interlock installed in your vehicle. You're not, for those 6 continuous months, you're not to drive any other vehicle other than your own vehicle that has the ignition interlock in it. I have the impression that your wife has a vehicle herself. Is that correct?
Yes, sir.
All right. During this 6 months continuous, you're not to drive her vehicle unless you put an ignition interlock in it, which I would be very doubtful that you would do. Is that understood?
Yes, sir.
All right. Now, scroll. The supervisory fee, Mr. Carney, will be $38 a month. Now, you heard what I had to say. You have the option to say you want to start all over again. You don't accept the increase in the fine. It's up to you. And Mr. Slimane, do y'all want to confer on that on your own, or do you want to accept this at this time?
Can I have 30 seconds in the breakout room with Mr. Carney, Your Honor?
Absolutely.
Thank you.
Ed Piker. Ed Piker.
He needs to unmute.
Hmm?
He needs to unmute.
He's scheduled at 10:30.
There I am. I'm back. You hear me now?
Yes, sir. Are you ready?
Okay.
Are you ready on Hathorn?
Yeah, he's right here with me. See him there?
Yes, Your Honor.
All right. We'll be with you within 5 minutes at the most.
All right, Justin. I'm going
Appreciate
back on
you being-
mute.
Yeah, I don't know why Miss Corley is on. I don't see her name on the docket for anybody.
Who?
Linda Corley.
I'm actually here because I got rehired this morning on a case that I think is on the docket this morning.
And which one is that, ma'am?
That is Jonathan Roden, Rhoden. Case
I don't
number,
remember that name.
I can give you a case number if that's more helpful.
The first one on page 3, Judge.
Okay.
652-807.
All right. Yes. All right. We found it.
Okay, so I don't believe, we've submitted another notice of appearance, but I don't think it's been accepted by the clerk yet, but it has been submitted, Your Honor. And I just wanted to make the appearance. I want to make sure he doesn't end up with a warrant, Judge, and I can get him to log in if you need him to.
I just want him to report in to Ms. Garcia, make sure we know that he is around, he is available, and he should have been here at 9 a.m., but okay.
Well, I didn't get the link, and he didn't. I don't believe he had an attorney. And I just finally called Linda in the clerk, and she gave me the link. So I just logged in as quickly as possible. So I do need to have him log in. I'm sorry, I don't know who Miss Garcia. Who's Miss Garcia?
I'll accept your word as an officer of the court that he is available.
He is, Judge. We just talked with him this morning, so yes, sir.
All right. So what are you going to do today? You're going to confer, or you just reset it?
I'd like to confer, Judge, if I can.
You'll have to wait a while because we've got 2 pleas. It'll probably be like 11:30 before you actually get to confer. You want to come back and join us at that point?
I'll just mute myself and take my video off, and then just when you guys are ready for me, call my name and I'll be here.
All righty.
Okay, thank you, Judge.
You're welcome.
They're back, Judge, from conferring.
Mr. Slimane, what says Mr. Carney?
Your Honor, my understanding is that Mr. Carney would like to proceed with the plea.
All right. Then, Mr. Carney, you've heard everything. You do need to come by within 7 days. I need you to come by to the offices of County Court Law Number 5. You have to have, by law, your thumbprint placed on the different documents. So you have 7 days to do that. Otherwise, this whole proceeding is completed. If you have questions, right now, there's a lady named Maricela Luna, who's my court liaison officer. She's going to talk to you, visit with you, and set up the probation part of this, the supervision. If you have any questions, ask her. If in the future you have any questions or problems, get in touch with the court or the office, and we will resolve whatever questions you have. Don't get yourself messed up because you failed to ask questions, okay?
Sure.
All right, good luck to you. Stay out of trouble. Take care of your